The Massachusetts Wage Act is very dangerous for employers in Massachusetts. It's unique amongst the states in that a violation automatically results in triple damages to an employee, as well as attorney's fees and costs. Once an employee has filed an action in Superior Court or in federal district court, they are entitled to triple damages even if there's been a late payment of wages. I will go over what is a wage and what is not a wage. In addition, under the Massachusetts Wage Act, it's spelled out that a president, treasurer of a corporation, as well as any officers or agents having management of such corporation are considered employers under the Wage Act and can be sued individually for a company's failure to pay wages. So if you have a company that's insolvent or bankrupt, a plaintiff's lawyer will certainly go after the individuals that he or she is able to go after to try and collect the wages that were not paid. The Massachusetts Wage Act requires that an employee who is discharged from employment, meaning the termination is involuntary, is paid all wages in full on the date of discharge. So saying we're going to put your check in the mail or we'll get you at the next pay period, that is playing with fire. And for a Massachusetts employee, and especially for companies that are not based in Massachusetts and don't understand that, are used to how other states operate, this can lead to some danger. And I'll explain sort of the parade of horribles for you later on. You cannot retaliate against an employee who complains about an alleged failure to pay wages as well. I would hope that none of you would do that anyways, but just if you do happen to discharge or otherwise take adverse action against an employee for complaining about a failure to pay wages, you are in violation of the Massachusetts law. So what is a wage? Meaning what must be paid on the date of discharge? What can be subject to treble damages? Base compensation is a wage. I think that's pretty self-explanatory. If it's a salary, hourly rate, draw against commissions, those are wages. Accrued vacation or paid time off, that is considered a wage. Once an employee has earned vacation time, that employee must either use it or be paid for it. Now, one thing to be clear about is that there can be a cap on the amount of vacation or PTO that an employee can accrue, as well as employers can have a use it or lose it policy for vacation or PTO, but that needs to be in writing, it needs to be communicated to employees, it needs to be clear, it needs to be enforced uniformly. And finally, commissions are wages. I will go through the difference between a commission and a bonus in a minute, but commissions are wages, bonuses are not wages. Two other categories that are not wages are sick time and severance. Those are not considered wages. I want to be clear that I hope no one takes away from my presentation that you can decide not to pay severance because of this presentation. I'm just being clear that severance is not something, if there's a failure to pay, can result in treble damages, president, treasurer, and managers of the company being sued for. It's just, those are not wages, but still, if you owe them to your employees, please pay them. So going through the difference between a commission and a bonus. Under the Massachusetts Wage Act, a commission is a wage if it is definitely determined and due and payable. So those are, and I'm quoting directly from the statute. What definitely determined means is if it is subject to calculation. So if you have a commission plan and it says that an employee will get a percentage of a sale and that sale has been made, it can then be calculated. You know that if you have a 40% of a sale of a gross sale commission plan and the sale is $10,000, the employee has earned $4,000. Due and payable means that all contingencies for payment have been satisfied. So that means that if you say we need to wait a year to make sure that the client doesn't terminate the contract before the commission is paid, and if the client does not terminate the contract, then you are owed the commission. That is the type of thing that makes a wage due and payable, rather than just something that the employee has in the process of earning. And that requires a very close review of your commission plan to make sure it's clearly articulated. we have a case currently pending where there's an ambiguity that's being exploited by a departing employee for that. Commissions in general, and this is very much in general, are non-discretionary, and they're relating to the completion of a sale or closing of a transaction, relying on a commission plan. A bonus, on the other hand, is generally discretionary. It is usually tied to either some sort of anniversary or date or a company-wide performance. So if you provide your employees with a year-end bonus, that is not going to be a commission. That's not something that the employee earned. It's just something that came when a certain date passed, as well as if a bonus is tied to a company's performance. If a company meets a certain threshold for revenues, that's not a commission for the employee. So I would say, in general, as a rule of thumb, if this type of compensation is tied to individual performance, work on specific deals, that's typically a commission. If it's tied to company-wide performance, that's typically a bonus. So it would not be considered a wage under the Wage Act. Now, I have a little shrug emoji, because if you're a little confused by it, you aren't the only one. This has caused courts some confusion. This issue is frequently litigated, whether we have a commission, whether we have a bonus, because obviously the pot of gold for an employee is to prove that they've been deprived of wages. That gives them treble damages, attorney's fees, and costs. If it's a bonus, then they bear their own attorney's fees and costs, and there's no mandatory multiplier for the damages. Courts do recognize that there's a gray area between the commission and the bonus. The one thing I would caution about is, if you tell your employees, we're going to give you a bonus, but in reality it's a commission, that's not going to protect you. So how you title what the compensation is not really going to matter to a court. It's going to be whether it's arithmetically determined and due and payable to the employee. So a few tips from the Davis-Mom employment law team about avoiding the dreaded Wage Act complaint. And it really is dreaded Wage Act because it really has teeth. It is a huge piece of leverage for employees, and it can be downright scary. So the first step to preventing the Wage Act complaint is to promulgate and enforce written policies and ensure that they are in writing, that they are communicated to employees, and that they're uniformly enforced. Something that we've seen come up in the past relating to vacation and PTO policies is if there is ambiguity as to whether vacation is capped or if there's a use it or lose it policy. If it's communicated orally to employees, we don't cap it, if it's communicated orally, well, we're never going to cap it, we're going to reward you for taking vacation time, and then in writing it's ambiguous, then an employee will say, I have 18 weeks of vacation after 5 years of service. They might even say, I didn't take vacation because I thought I was accruing all this and having a nice little nest egg. So you want to make sure you also track your employees' vacation and PTO. If you want to have a cap or a use it or lose it policy, you need to make sure that's in writing and communicated to the employees. Commission plans as well, same thing. You want to make sure that they are well crafted, that any contingencies that need to be satisfied are in writing, provided to the employees, made clear. If one contingency is when the payment is received by the company, then you need to make sure that's in writing. Otherwise, you might get stiffed on a bill and your employee might still come to you and say, where's my commission? And you won't be able to rely on the commission plan if it's not put forward there. Another thing to do is, in HR, obviously, HR, you would have some familiarity with this. Managers, not in HR, might not have familiarity with the Massachusetts Wage Act. You want to make sure that they know that an employee who is discharged must be paid in full on the date of termination. And that includes vacation, earned vacation, and includes commission. Because a manager might say, oh yeah, we terminated so-and-so today, I just wanted to let you know. But if they've walked out without their last check, they might walk right into the Attorney General's office, get a right to sue letter, and bring a suit. Now, once they file suit, again, even if the check's in the mail, that check will only be an offset on the triple damages, and that can happen within a week. So I know that I think all of us in our practice, if we talk to an employee who's been discharged, I think probably one of the first questions we'll ask is, have you been paid in full? And if the answer is no, then it's okay, we have something to work with here to use leverage with your former employer. And I think any competent lawyer in Massachusetts will ask that. That'll be the first question. The other thing to remember is, obviously I think best practice is to work with an attorney when drafting severance agreements for employees. But if you want to do that internally, you want to make sure that a waiver of the Massachusetts Wage Act is spelled out conspicuously in the release. Otherwise, there will be a potential argument that they haven't waived the Massachusetts Wage Act claim. Typically, we put it in all bold. Happy to answer questions about the Massachusetts Wage Act. Sure.
If an employee has used more than their accrued vacation when they leave, are you allowed to take that back?
That depends on what your policy states. I think as a matter of the Wage Act is silent on that. Now, if you have a policy that there needs to be, the employee needs to pay back into the system, then that's one thing. If it's silent on that, then I would say no.
Paying the wages when somebody leaves, I get that. Most people understand, they give the check. The real danger, or a significant part of the danger, is with vacation and with overtime. And a lot of people still think that with overtime, all you got to do is pay salaried. You don't. You have to meet those three categories: administration, executive, or professional. And I'll just give you, and then, so that's one thing. And then the other issue is with regard to vacation time. I'll give you two examples within the last couple of years of cases that I was involved in. One involved a C-suite executive. The company did not have a clear use it or lose it vacation policy. And it cost them $500,000 because this employee had accrued. Another situation was with overtime. They had their job description. They thought they'd met the executive qualification because they said his job responsibility was to supervise. But those tests are based on the actual situation of the job. You can have a job description that says these are your duties, but if actually the person does not have those duties that fit the exemption, there is no exemption. And in this situation, you had an employee who supposedly met the executive. He would have had maybe $30,000 of overtime. To settle the case, it cost him $100,000. So you really, those areas you want to look at to make sure that your people are actually working when they're doing, and they fit the overtime exemption, they're performing those duties and responsibilities. And vacation, you've got a clear policy, use it or lose it.
Regarding repayment of unaccrued vacation time at the time of separation, that you cannot automatically dock someone's pay. You're not going to want to withhold that from their paycheck. Even if you have a signed agreement with them or a policy, you're going to want to ask them to actually write you a check. You can't just take that out of their pay, so be careful for that.